First is COVID related issues and litigation. Now, what is that? You would see that all these prices of face masks and the PPEs and all the essential services have gone up. That's an unforeseen situation which is there, maybe caused with a demand shortage, maybe caused by other anti-competitive factors. Now, there are various antitrust authorities which are there. I've taken a note. There's EU which has come out with a notification. There's Italy, there's Poland, there's Norway, there's South Korea, there's US, there's UK. All saying one and the same thing. Obviously, the language is totally different. All saying one and the same thing, that we are in an unprecedented situation. Please do not use tactics which are opportunistic in nature, which essentially means that you should not use tactics which harm the consumers in any manner in terms of higher pricing or lower quality. But as they say, the profit motive or greed takes over everyone. They are people, they are enterprises which actually engage in conduct like increasing prices, etc. In other jurisdictions, and there are jurisdictions like Poland, for example, they have stepped into this. What had happened was there were certain behaviors by wholesalers of these face masks, which they said will not supply to hospitals but will supply at open market, just increasing their profit margin. So Poland came down heavily on that. Then Italy came down heavily on Amazon and eBay because they were doing excessive pricing of sanitizers.
Yes.
Unfortunately, CCI just came out with an advisory which essentially says that you can collaborate provided that is in public interest or innovation, as the case may be. But that to me is just rehashing the existing law as it stands today. What you need in certain times like this is for a regulator to stand up and take notice and maybe issue some kind of a stern notification or a guideline saying that no opportunistic behavior will be allowed. Why I'm saying so is the face mask. I was doing some Google search. The price of face masks have increased by 300% from the pre-lockdown era. Although face masks and sanitizers were brought in under the Essential Commodities Act, thus capping the price, unfortunately, the extent of the notification or the timing of the notification was only till June 30th. And I read somewhere that the ministry is not planning to increase that. So as on June 30th, the Essential Services, Essential Commodities Act, for example, which somehow caps the prices of these face masks and the raw materials for preparing these face masks or sanitizers, as the case may be, this restriction no longer applies. So now you will get a zoom in, not Zoom, the Chinese app, but the Zoom, the increase of the prices of these prices. And it's very, very essential for a regulator to come and step in to ensure these conducts do not happen. Yes, there are challenges as far as the law as it stands today. Can you go after such multiple enterprises? Can you not? But these are subsequent issues, in my opinion. At times, the regulator needs to come out and say these are the issues which are there, and do not engage in such conduct. Now that the CCI hasn't come out with those notifications, I'm of the opinion that there will be such kind of behaviors which will happen in the future, which will in turn lead to multiple litigations because there will be filings before the CCI saying that AB's company ABC, which is engaged into essential services, be it anything, be it PPE, hand masks, sanitizers, the works, all the essential services, are engaged in behavior which is increasing the prices. So please investigate. And CCI, considering the situation, may also initiate an investigation. And unlike other investigation which takes in its own sweet time, for a lack of a better word, this will be a very speedy kind of an investigation. So this is one thing which in European Union is colloquially now referred as crisis cartels, which basically in crisis you come and form a cartel or whatever be that name it's called. Under Indian law and European law, there's no difference as such. So unless you can show that you have given some efficiencies to the consumers, efficiencies in form of that we want to pull in resources so that the consumers get all the prices, all the goods at affordable prices and quickly. We had to pull in our resources, like supermarket chains, example. So these are the things which will be very litigious in the next 18 to 24 months, is what I am of the firm opinion. So this is something, and we as Competition Commission of India should take reliance and should see the conduct which is happening on the west as well as on the east. We have all the countries all across the globe issuing stern warnings, issuing starting investigations. So, for example, Turkey has started investigations against 29 wholesalers already,
Oh,
29 supermarket chains for increasing the prices. Now, the question can be, can you initiate an action against 29 companies if it is not a cartel behavior? But that is a subsequent issue. That is a litigation issue. That is an investigation issue. At least initiate an investigation. If you initiate an investigation, there is a high likelihood that this behavior may or should be curbed. So this is a trend which I'm definitely seeing in the next 24 months. Is my first point.
so I think we can then safely say that a lot of JVs are in store. Like companies may enter into, they will have, is do companies get incentive to enter into co-marketing agreements, or let's say sharing resources, or let's say co-supply agreements in this particular scenario? Do
Yes.
we do we see possibilities of that happening?
So yes, as a trend, as a compliance perspective, I am surely seeing sharing of resources, pooling in of research, R&D, co-marketing, like you said. But those are the then as a compliance perspective, as an in-house perspective, or somebody who's advising the company, you have to make very sure that in the agreement and also in practice, it is leading to efficiency. Just creating a joint venture or just creating an agreement will not take you outside cartel provisions. You have to show that your JV has increased efficiencies in the market. Basically, not going to specifics. How do you increase efficiency? One will be administrative efficiency, that basically because of this huge demand and supply constraint, because the factories are closed, the workers have gone back.
Yes.
You're only operating at 50% capacity, so your supply would be limited. So let's pool in all our resources. That way, we'll have cost savings and
Yes.
consumers efficiency, because then you're giving all the products in time. But on the flip side of it, you should not be engaging in supranormal profit behavior. That okay, fine, we pull in our resources. There is a inherent vast demand. The supply is less, so increase the price, which otherwise would have been say 10 rupees. You are now charging 300 rupees, which unfortunately is happening now. Whether it's for cartel behavior or actual supply shortage is an investigation point.
Yes.
But this, I definitely foresee that there will be investigations in this regard in the near future. Once it comes out, you never know. Information could have been filed, because we do not know. Nothing has come out in the press, to my knowledge. But you never know. Some information may have been filed. If not, it should be filed in the near future.
But sir, can companies take a defense? Like you mentioned that the in the agreement, it should be clearly stated that what are the efficiencies that are arising out of this particular agreement, which is not really the same that was there before. That agreements were not mandated to give out these things, but now agreements have to clearly state it. Can one such reason be, let's say, two companies feeling that if they don't enter into this agreement, they may go out of business, and to safeguard their future operations, maybe economic efficiencies are not arising, but just to safeguard their operations and to ensure that they don't go bankrupt, they enter into a collaboration. Will that act as a defense for
Yeah.
the
So
company?
this is colloquially referred to as a failing firm defense,
Yes.
wherein you are saying that if it continues like this, I'll go out of business. So I'm pulling in my resources, because if I go out of business, ultimately the consumer is harmed, because I will go out of business. So I am no longer a viable alternative in the market, because
Yeah.
I'm outside the market. So ultimately the consumers will be affected. But the reason is, it's a very thin line.
Yeah. Exactly.
It's a thin line where you have to err on the side of caution. When I say err on the side of caution as a regulator, at least investigate whether they are actually doing these efficiencies or not. As a compliance point of view, from a company's point of view, obviously these are the defenses that they will take, provided it's documented both in agreement and actual practice, whether it's agreement or internal white papers, or board papers, whatever name you call it. It need not be a form of the agreement, but it should be a contemporaneous document. You should create it now, not wait for the litigation, because that will have no evidentiary value. And obviously, in practice, you need to adopt that. So it should be so the standard is it should be proportionate to your efficiencies. So you should actually attain those efficiencies and enter into JV, which helps you attain those efficiencies. But having said that, circling back to my initial point, as a trend, I do see a lot of investigation which will happen in this regard.
Yes, sir. So now that you've said that you foresee a lot of investigations in future, but what is the current state of the Competition Commission of India in terms of being a regulator? Like, what is the state of the litigations? Is CCI entertaining any information, or is the CCI having hearings right now?
Unfortunately, in my cases, hearings have been deferred.
Right.
Information, yes, they are being filed, so that is allowed. But hearings haven't happened to the limited matters that I am doing. I'm told that there are a couple of hearings which have happened, but that is few and far between. On merger control, yes, apparently the green channel route and other routes and other things are going on. But
Yeah.
since we are sticking on enforcement, I don't think many hearings are happening. Especially in my matters, everything is getting postponed. Fresh matters filings is happening, but again, prime officer hearing is not happening. So that's a sad reality right now. I think the CCI should take cue from the Supreme Court and the various high courts and start online hearing. Which one point I think sooner than later they will start, because they were worried about confidentiality, which I agree, because it's a business regulator. But they have to find some safeguards from one point of time to another, because the show must go on, as we say.
Yeah.
So the online hearings is the way for the future, for the foreseeable future. So it must go on. You can't have a regulator, especially a market regulator, and any regulator, be a securities regulator also. Even SAT has started. Securities Appellate Tribunal has started. So
Absolutely.
you can't have a market regulator which is functioning at a less than an optimum capacity. So that should not happen.
So you would, despite the current function of the CCI, you would still advise clients to go towards filing an information before the CCI if they come across any such disruptions
Oh,
that are happening.
oh, completely. The act. So okay, I should have rephrased. The act is not suspended. The act is continues to exist. There's no suspension of the act. So just as a layman, just to take a very offbeat, a very digressing example, there's no moratorium on the act. The act is completely operational. There's no question of a company engaging in malpractices as far as competition law is concerned. So if an individual or a consumer body or anyone for that matter, for example, as a dealer, if there's a very strong phase mass supplier which is not giving me the product, obviously a dealer can go and file a complaint. So I would certainly advise companies or individuals to file information. Let's not wait for that.
Absolutely.
There is a procedure which is given. There is an email address which is given onto the website. You obviously have to pay the filing fees, and
Yes.
they accept information by way of emails.